My name is Mohammed Abdulllah Fareed. My US student number is 2405803. Introduction. Before understanding this situation, it is necessary to understand this history and the legal constructs of this act. The main law used in the sale of good act 1979 is the law governing the sale of the tangible or movable property in the UK. It ensured that the act will always provide protection to the buyer and the under variation implied terms which are considered by considered conditions of the contract between the considered parties. The legal analysis will also provide aspects of the section 35 and a summary of the available remedies under section 50 to 53. The table Salman commissioned 25 extra large grey marble table. He was provided with 10 medium marble table with 9 wooden table and 1 extra large grey marble table. In this case, the description and quantity are the main areas of violation in the contract. Breach of section 13, the sale. Breach of section 13, the sales of description. The sale. Section 13, sales of good act 1979 implies a condition that there were good are sold by the description, that the good must correspond with that description. In this case, the description is slide 25 extra large marble grey table received. It was found that the person received a delivery of table with include medium sized table made of wood, and the total quantity was 20, not 25. The medium size and wooden material clearly fails to correspond the contract description of extra large marble grey table or even table in this case of wood. Case law. The principle in across limited versus EA resume and Sun provides strong spots for Salman in across. The goods delivered were slightly thicker than described, and the court held the buyer inclined to reject the whole consignment because the good does not strictly correspond to the description. Missing table, the remaining 5 tables were negative delivered to or not substituted or are a simply breach of the constitutional duty for the supply to quantity order conclusion on tables. Salman has the ability right to reject the non-conforming tables, medium and wooden, for breach for the constriction of under section 13. The sofa. Salman purchased leather sofa set after specifying asking Salman whether the leather could irritate those with skin conditions. Salman resumed him that the leather was the highest quantity and there were no issue in exchange. Rise for the issue of the fitness in the purpose of satisfactory quantity. Breach of section 14.3, fitness of the particular purpose. Section 14.3, sales of good act 1979 implies a condition that there will be a buyer explanatory and or immediately makes known the seller any particular purpose for which the good are being bought. The good must be reasonably fit for that purpose. Particular purpose. Salman explicitly committed a specific requirement that the leather should not irritate skin condition. This goes beyond the normal general purpose of the sofa setting. Reliances. Salman relied on Salman's skill and judgment. Salman reassured him that Salman agreed to purchase on that basis. Breach. The immediate reaction of Salman's daughter Resh and itching demonstrate that the sofa was not reasonably for the particular purpose made known. Case law. The case law of Giffen versus Peter Conway Limited supports this as it established that if a buyer has known abnormality, in this case of sensitivity and to certain leather chemicals, and make this known, the seller must ensure the product as it is fit. Here Salman made the general conclusion about skin conduction known. The rash is strong evidence of the breach of section 14.3. Breach of section 14.2, satisfactory quantity. The statement that the leather is of high quality can also be used for the argue of breach of satisfactory quantity. Section 14.2 implies a condition that the goods supplied under the contract are the satisfactory quantity. Section 14.2b defines the satisfactory quantity including fitness for all the purpose for which good that kind are commonly supplied. Conclusion on sofa. Salman has a strong right to reject this sofa for breach of the condition of fitness of particular purpose. Section 14.3 are likely satisfactory quantity. 14.2 the rash of provides definite proof that it defeated the chairs. Salman ordered 100 chairs. Velvet dining chairs which were reduced by 50% because they are displayed with minor wear and tear only. The chairs received had grease marks on the circumference of the bottom. Breach of the section 14 to satisfactory quantity. The conclusion point here is the qualification given by the seller. The term satisfactory quantity is in section 14(2). Applied by section 14(2)(c) states that the implied condition does not cover defects that are specifically down to the buyer attention before the contract is made. Agreed defects. Salman was told of minor wear and tear. He has said this. He defects falling under the definition cannot be claimed as a breach. Unagreed defects. The presence of grease mark on the back and exclusive suffix go beyond minor wear and tear are not defects. Salman's primarily viewing would have revealed for every chair, especially for those packed in boxes. Grease marks are in particular affects the appearance and finish and freedom from the minor defects aspects of the satisfactory section 14(2)(b). Case law. The case law of Roger vs. Parvesh Limited established that quality has judged by the reasonable person who could regard as satisfactory considering the price of and description. While the price was reduced, the defects of grease mark is significant for the restaurant that needs to maintain the professional appearance. Conclusion on sofas. Conclusion on chairs. The chair that suffered from grease marks are likely to be in breach of section 14(2), as these defects were not pointed out as exclude that a reasonable person could consider minor wear and tear on EX display term items. Appearance, acceptance and inclusion. Summons claim that it's too late to cancel order, but the exam against section 35 Sale of Good Act 1979, which governs when a buyer deems to have accept the goods, thereby losing the rights to reject them. Section 35 acceptance. A buyer is deemed to have accept the goods in three main circumstances. Section 35(1). Number 1, he informs the seller for his acceptance. Number 2, he does not insist with the ownership of the seller. Number 3, after the lapse of the reasonable time, he returns the good without informing the seller has been rejected them. Inspection. Clearly, the buyer is not deemed to have accept the goods until he had a reasonable opportunity of examining them for the purpose of the acceptance, whether they are the conformation with the contract. Section 35(2). Given the large order of the 131 item table and chairs, reasonable time. The constitution's reasonable time is a question of fact. Section 35(4). But the factory furniture rejection by calling the next day starting he is unhappy and wishes to return the goods. Salman clearly excited to reject within the reasonable time. Conclusion and reminders. Salman has a legal position to reject all the tables and sofa and significant proportion of the chair due to breaches of the compiled condition of description and the quantity under the Sales of Good Act 1979. Reminders under section 1979. All the breaches of the condition. Salman is entitled to the following: rights to reject. Salman can reject the entire consignment and treat the construct repeatedly under the section 13. Demand of non-delivery, section 51. Demand of breach warranty, section 53. Demand for losing arises for the breach equality laws. Salman could then claim for all the injury and associated, for example, medical bills insured by his daughter as a result of breach, section 14(3). Conclusion. In summary, Salman could maintain his demand to reject all the non-confidential goods, tables, sofas and chair, demand a refund or the delivery of confirming goods, a claim for any resultant loss. Summons accept to enforce payment is legally unsound. Thank you.